Let's first talk about the bona fide employment requirement. At first glance, there's no information indicating that the court decision, that is IT Serve Alliance Inc. versus Cessna, has been altered in any way by these new H-1B regulations. Just to give you some background, in this 2020 case, the US district ruled against USCIS, and they said that the USCIS policies that had been imposed were too stringent, and especially with reference to employer-employee relationship and with reference to the itinerary requirement. It was too stringent, and it was against regulations. So, following the court decision, USCIS issued a memo, and they agreed to rescind these restrictive policies and to reopen some of the cases that were denied due to these policies. They, however, said that they could still request documentation for bona fide employment. That's what we're talking about, bona fide employment, if anything has changed in the new regulation. So even at that time, the court decision said that they could still request for documents in order to show that the job was not speculative and that the company had a bona fide specialty occupation work available for the beneficiary. But however, in practice, since 2020, USCIS has not been asking for end-client letters, purchase orders, contracts, MSAs, and even the Department of State, the consulates, were asking for it. They took a while to change their practices, but they had stopped asking for client letters as well. But with this new regulation, they specifically say in the regulation that the employer has to show that they have bona fide employment for their employee, they have enough specialty occupation work, and if it's a consulting company, then they should submit documents such as client letters, POs, work orders to show that there is sufficient specialty occupation work.